Last year, legal AI adoption jumped from 19% to 79%, while lawyer employment quietly hit record highs. AI-powered systems now draft contracts that are 94% accurate in minutes, and they shaped 90,000 court opinions in China alone. Yet Western constitutions still require human judges. If machines are faster, smarter, and everywhere, why are more lawyers thriving than ever? The AI gappening has already begun, but the real question is not who gets replaced. It is who adapts before the rules change again. Startups promising to revolutionize legal work now attract billion-dollar valuations, drawing investors from Silicon Valley to London. In just 2 years, legal tech funding has outpaced funding in the previous decade. Harvey AI, piloted by global firms such as Allen and Overy, now A&O Shearman, is rolling out AI tools to more than 3,500 lawyers across 43 offices. These platforms process contract analysis, due diligence, and litigation research at speeds that would have been unthinkable only a few years ago. Revolution. Major legal research companies are pouring resources into advanced AI, with sector-wide impacts estimated at $32 billion annually. Law firms and in-house legal departments are increasing their AI budgets by more than a quarter, and 57% of legal organizations plan to boost AI investments in the coming year. The Big Four accounting firms, EY, Deloitte, PwC, and KPMG, have committed billions to legal AI platforms, deploying these technologies to thousands of professionals worldwide. EY's $1.4 billion tech legal platform is one example of how these firms now compete directly with traditional law practices, not only in accounting but in legal services powered by AI. Impact. Adoption is no longer limited to early adopters or tech-forward boutiques. Hundreds of major law firms, spanning over 40 countries, have integrated AI into their daily workflows. In larger firms with more than 50 lawyers, adoption rates have climbed to nearly 40%, while smaller firms are quickly following suit. Across the industry, 80% of professionals now say they are confident using AI, and 95% expect generative AI to become central to their work in the near future. Adoption. Performance benchmarks are breaking records. AI contract analysis tools now achieve 94% accuracy, surpassing the 85% average for experienced lawyers. E-discovery platforms can process millions of documents in a single hour, cutting review times from weeks to mere hours. For law firms, this means savings of 2 to 3 hours per lawyer each week, translating to hundreds of billable hours reclaimed annually. The average U.S. legal professional using AI now delivers $19,000 in added value each year, with the combined impact across legal and tax sectors estimated at $32 billion. Accuracy. The scale of this transformation is visible in daily practice. At A&O Shearman, lawyers submit thousands of AI queries monthly for real client work, drafting contracts, summarizing regulatory changes, and analyzing litigation risk. Big Four firms use AI to track market sentiment, monitor compliance, and automate reporting across continents. These systems are not just faster, they are setting new standards for accuracy and reliability in tasks that once depended solely on human expertise. Scale. What began as a trickle of experimental tools has become a flood of mainstream adoption. AI is now the plumbing of the legal industry, invisible, indispensable, and everywhere. The question is no longer whether legal AI will be adopted, but how quickly firms can scale up and keep pace with the new normal. Industry. In 2024, Chinese courts quietly processed over 90,000 judicial opinions with help from artificial intelligence. These systems, deployed in civil and commercial cases, work by analyzing case files, comparing legal facts, and drafting the reasoning behind decisions. The process begins when a judge uploads documents into the court's secure platform. The AI reviews the data, scans for relevant statutes and precedents, and produces a draft opinion. Every AI-generated text is reviewed, edited, and signed by a person in a black robe, never by a machine. In one commercial dispute, the AI system sorted years of contracts and prior rulings in seconds, suggesting possible outcomes and legal arguments. The judge used those drafts to shape the written opinion, saving hours on research and paperwork. Across China, these tools now support thousands of judges, handling routine analysis and freeing up time for complex deliberations. State-backed technical guidelines emphasize a clear boundary. AI assists, but does not decide. There is no room for autonomous robot judges. The Western legal world draws a much firmer line. In the United States, the Constitution requires federal judges to be nominated by the president and confirmed by the Senate. Every state court system has its own rules for appointing or electing judges, but all insist on a living, breathing person in the role. European courts follow similar principles, with human judges at the center of all proceedings. Despite viral stories and science fiction headlines, no country in the West has authorized AI to issue binding legal decisions. Estonia's much-publicized robot judge pilot was quietly shelved after public debate. In the United States, the idea of a fully automated judge is blocked not only by law, but by deep-rooted traditions of fairness, accountability, and open justice. Chief Justice John Roberts put it plainly: AI will transform the legal system, but it will not replace judges. Courts may use AI to draft opinions, summarize evidence, or flag inconsistencies, but the judgment and the responsibility remain human. The distinction matters. In China, AI is a tool for efficiency, working behind the scenes. In the West, legal systems treat the act of judging as a uniquely human function, protected by constitutions, statutes, and centuries of precedent. The debate is not about whether AI can help, but about how far it should go. As these systems become more capable, the line between assistance and replacement will be tested again and again. For now, the world's legal institutions are drawing that line with care. Across the United States, courtroom decisions with life-altering consequences now often begin with a number generated by a machine. Algorithmic risk assessment tools such as Compass and the Public Safety Assessment are in use in at least 46 states, shaping outcomes in bail, sentencing, and parole hearings. These systems promise to bring science and objectivity to decisions that once relied on a judge's intuition. The reality, though, is far more complicated. The Compass tool, built by Equivant, draws on data points like prior arrests, age, and employment history to predict the likelihood that a defendant will reoffend. In theory, the algorithm is blind to race and background, but the data it uses is anything but neutral. Historical arrest records reflect decades of unequal policing and prosecution. As a result, Black defendants are labeled as high risk, at nearly double the rate of white defendants, often with no more actual risk of reoffending. In Broward County, Florida, a ProPublica investigation found that Black defendants were falsely flagged as future criminals twice as often as their white counterparts. Meanwhile, white defendants were more likely to be misclassified as low risk, even when their records suggested otherwise. For people like Eric Loomis in Wisconsin, these scores are not just numbers, they are part of the official record. When Loomis challenged his sentence, arguing that a secret algorithm helped determine his fate, the state's highest court sided with the status quo. Judges could use Compass, the court ruled, as long as they acknowledged its limitations and did not treat its output as the final word. But the code behind Compass remains proprietary. Defendants cannot see how their risk is calculated, and judges cannot fully interrogate the logic behind the recommendation. Vendors defend these tools as evidence-based and point to studies claiming accuracy across racial groups. Critics, including civil rights lawyers and data scientists, argue that the appearance of neutrality masks deep-seated bias. The debate is not just academic. Mistaken high-risk scores can mean longer jail stays before trial or harsher sentences, especially for those who cannot afford to post bail. Lawsuits have challenged the use of these systems, but no court has imposed a blanket ban. Instead, some jurisdictions are beginning to restrict or audit risk assessments, requiring greater transparency and reminding judges that these tools are meant to inform, not dictate, justice. For defendants facing a bail hearing or sentencing, the consequences are immediate and personal. A single algorithmic flag can tip the balance toward detention, even when the facts do not support it. The promise of fairness through automation now collides with the reality of entrenched inequality, raising hard questions about whether justice can truly be coded into a black box. In 2023, a New York courtroom became the stage for a startling revelation. Attorney Stephen Schwartz, representing a client in Mata versus Avianca, submitted a legal brief filled with 6 citations, each one fabricated by ChatGPT. The cases looked legitimate, complete with plausible names and legal arguments, but none existed. When opposing counsel searched for the sources, they found nothing. Judge Kevin Castell demanded an explanation. Schwartz admitted that he had relied on output from an AI system without checking its accuracy. The court imposed a sanction of $5,000 and ordered the mistake to be made public. The warning was unmistakable. Artificial intelligence is not a substitute for human diligence. Mata versus Avianca was only the beginning. By 2025, at least 25 cases in U.S. courts had surfaced where lawyers or litigants submitted citations generated by AI that simply did not exist. In Arizona, the Mavey versus Commissioner of Social Security case revealed that 12 out of 19 references in a disability appeal were the product of an AI tool. The judge responded with sanctions and required the ruling to be attached to all future filings. In California, a lawsuit against OnlyFans' parent company saw 3 separate briefs with fake quotes generated by AI, prompting the court to call the conduct abusive. Consequences have escalated. Monetary penalties now range from $5,000 to nearly $60,000. Repeat offenders face suspension or must disclose past sanctions with every new filing. State bars have begun disciplinary proceedings against attorneys who fail to supervise their use of technology. Even those representing themselves have been caught. Motions filled with citations that collapse under scrutiny, sometimes with non-existent lawyers named in the pleadings. In Texas, a judge denied a default judgment after discovering that both the attorney and the cited cases were inventions of an AI chatbot. The problem is widespread. Over 300 court filings with fake citations have been documented across federal and state courts. Judges now routinely scan for signs of AI hallucinations, authorities that cannot be found in any reporter, persuasive quotations with no source, and arguments built on fiction. Benchmarking studies show that specialized legal AI tools fabricate or misrepresent authorities in at least 16% of test queries, with some sanctioned briefs containing up to 2/3 false citations. General-purpose models fare even worse, with hallucination rates between 17 and 34%. Law firms and bar associations are scrambling to adapt. New policies require attorneys to verify every AI-assisted output. Some courts demand disclosure when AI is used in drafting. Yet the incidents continue. 8 new cases surfaced in a single month in 2025, from Illinois to Florida. Each time, the pattern repeats. A lawyer or litigant, pressed for time or trusting the technology, watches their credibility unravel under judicial scrutiny. The hallucination crisis has forced the legal profession to reckon with the limits of AI. The risk is not just embarrassment or financial loss, but the erosion of trust in a system built on accuracy and integrity. For many in the legal field, the impact of AI is not a distant threat, but a daily reality. Take document review, the bread and butter of junior associates and paralegals. What once took 16 hours can now be completed by an AI system in just 4 minutes. In large law firms, tasks that filled entire workdays are processed in less time than it takes to drink a cup of coffee. Studies show that 22 to 23% of a lawyer's routine work is now automatable. For paralegals, the figure is even higher. Between 35 and 69% of their duties could be replaced by software. Sarah, a paralegal for nearly a decade, watched the work she once managed, sorting discovery documents, flagging key evidence, drafting basic correspondence, vanish from her desk almost overnight. Instead of reviewing contracts line by line, she now spends her days crafting prompts for AI systems and double-checking results. In just 18 months, Sarah retrained as a legal AI specialist, doubling her salary and turning disruption into opportunity. Her story is becoming more common as the profession pivots from manual process to a world shaped by technology. Law school graduates are stepping into the strongest job market the legal profession has ever recorded. In 2025, 93.4% of new lawyers found employment within 10 months of graduation, a rate unmatched in decades. Unemployment among lawyers dropped below 1%, even as automation swept through routine legal work. Law firm job openings have surged, with some surveys reporting increases of up to 30% year over year. Median salaries now top $150,000, and firms are competing to attract talent with experience in both law and technology. Demand for legal services continues to grow at nearly 3% annually, outpacing the broader economy. Rather than shrinking, the legal workforce is expanding, driven by new roles in legal operations, compliance, and technology management. The paradox is clear. While AI handles more of the repetitive tasks, it is also creating opportunities for lawyers who can adapt, supervise, and innovate. The profession isn't just surviving the AI wave, it is thriving as firms reimagine what it means to practice law in a digital age. Bar associations now require lawyers to verify every AI-generated output and to disclose when these tools are used in client work. In some states, AI competency is mandatory for license renewal. Courts have clarified that time saved with technology should benefit clients through lower fees, not higher profits. At firms like A&O Shearman, over 40,000 AI queries have streamlined real client matters, saving 2 to 3 hours per lawyer each week. Contract drafting is now completed 30% faster, with accuracy rates climbing to 94%. These gains are not just theoretical. Firms track metrics to ensure that quality and ethics keep pace with speed. Legal operations roles have surged by 75% in recent years, and data privacy specialists are in high demand, often commanding premium salaries. The legal AI market is projected to reach $7 to $10 billion by 2030, with workflow automation and prompt engineering becoming core skills. The real threat is not AI itself, but lawyers who refuse to adapt. Success now depends on mastering these tools, passing savings to clients, and building trust through transparency. Every day, algorithms decide who gets justice and who gets overlooked. As AI rewrites the rules of legal work, the line between machine efficiency and human judgment grows sharper. What is at stake is not just jobs, but the integrity of law itself. The future of justice depends on who holds the code and who holds them accountable. Tell us where you stand in the comments below.